Just as Luca said, I'm Levy-Golan, and I will talk today about the legal tools that the legal system actually allows us to use when we enter a phase of assisted living or a stage where we're not cognitively together as we'd like to be. And before I'll talk about the legal tools, I'll tell you in briefly about myself. In 2002, we moved to Australia. We had a mission to do there, me and my family. And several years later, my sister here in Israel said, you know, that is not 100%. He's a Jerusalemite, for 52 years had a business there, and he's like, he knows Jerusalem as a palm of his hand, but he started getting lost. He takes the wrong bus, he get off at the wrong bus stop, all of a sudden he's Kiryat Yovel, we live there, we found him elsewhere, and he got confused, and we realized things are happening, and they said, come back to Israel, we need you. I have only one sister, and we packed our house in Australia and moved back from Sydney to Ranana, but I had to make a decision. And that was actually the toughest decision I ever made in my life. I'm 62 years old, but never had to deal with a decision of should we hospitalized my father in an assisted living machlaka, in a department, because he was fit physically. He had to be in a closed department, in a machlaka siudit, which is locked, it's closed, he can't leave. And I realized, wow, that's a major life change. But it's the better choice rather than having him getting lost and getting hurt. He was he loved the shuk Machne Yehuda. He loved driving there, and then when he stopped driving, he took the bus, and then he walked. But we realized it's dangerous, and I had to make this decision. Eventually, Alzheimer hit us as a downhill, and for 6 years, it was at that department, and we saw the different stages. I mean, we were there for him, the different stages of the decline of the Alzheimer. At that stage, I was 53. I decided to switch my careers. I was a director, a TV director. I did 240 movies as a director, producer, but it was time to hang this hat, and I went to law school. And my specialty is how to deal with such situations and use the law in the most effective way, those legal tools that allows us to live in a best possible way, even though we might lose the cognitive ability. So what was the situation before several years ago when the law in Israel have changed? There was only guardianship. There was no durable power of attorney. And that's what my father had. My mom actually became the apotropos in Hebrew, the guardian. And that entails sending reports year after year to the Ministry of Justice, and literally like an account that you have to manage all the financial accounts of the person that you are a guardian of. And that's a big headache. Headache is an understatement. I mean, you submit those reports, and 2, 3 years and 4 years after my dad was passed away, they still call you and they say, what is this line here that you spent on this? We need explanation. You didn't give us that receipt. It's not fun. Well, the law at some point, the lawmaker realized that in Europe and in the United States, they already resolved this with a durable power of attorney, where you nominate a close person to take care and be the caretaker. And if you train them and if they sign the proper documents, you are released from all these reports. The Ministry of Justice wants to know if you've signed a durable power of attorney. They want to keep it in the register, and they want to know when it becomes effective. And that's a very big difference. I mean, anybody at any age, if you're over 18, could sign a verbal power of attorney. You can sign the verbal power of attorney and never activate it. It doesn't mean that my children or whoever I appointed has now the right to go into my bank account, into my financial affairs, into my personal affairs, or into my health affairs. Nobody can get involved until such time when this document that you've signed, I signed, so but me now, got into effect. What is the get into effect is the time when a psychogeriatric doctor gives you an analysis that yes, now this person can activate the power of attorney. Can be a psychiatrist too, that gives you, it can be a family doctor too in certain cases that say, I know this person for a long time. This person is now not legally, what's called in Hebrew, lo kashir mishpati, is legally incompetent. And at that moment, the people that I nominated, be it can be a family member, a child, children, several of them, depends on your choice. And it can be a professional. Some people have their kids in Canada and in Australia, and they're not around to take care of them. So you can choose a trustworthy person, like an accountant, like a lawyer that you know, but not the lawyer that signed you the document. Let's say, for example, if you choose a lawyer to sign with you the document durable power of attorney, that lawyer cannot have any benefit in your, is not a beneficiary in any way in your document, just to prevent conflict of interest, exactly. So let's read a little bit and hear about what this document entails. It starts with, do you want peace of mind regarding your future or that of your elderly parents? Many of my durable power of attorney was actually came to me through the children, that they saw their parents getting older and they said, Mom, Dad, this is the time. Let's do it now. You can make decisions, you can choose. And we'll talk later about what are the choices that you can make and how can you design your future when are you still cognitively strong. So that of your parents in case of not being able to make decisions. I'd like to start actually with comparing between, many people ask me, what's the difference between wills, durable power of attorney, and guardianship, apotropsut. So we mentioned guardianship is again a very close and tight monitoring by the Ministry of Justice. But the power of attorney, you have the nominee, and the nominee takes care of you. And besides the nominee, there is the observer. The observer is, let's say you have 4 children and say, okay, these 2 can take care of me of my finances, of my health. But I'd like the 3rd child, who doesn't live nearby, lives further away, or even overseas. I'd like him to be the observer. Observer means he's not physically taking care of you, but he needs to be informed. So another word to call him is the informed. In Hebrew, is hameyuda. You give him knowledge. You give him hameyadeh. You update them, and they're in the know-how, and they can make you. They can help make decisions, but they're not the actual people. That's the informed. So the power of attorney is for the period of someone's life. When is the power of attorney loses effect? When it's canceled? Upon the death, either of the person who authorized or the nominee, the appointee. There are other ways to cancel this document. We'll talk about them later, but this document is for the time of your life. Will. The will comes from the moment of death. In Hebrew, there's 2 ways after death to see how to handle the estate. If someone wrote a will, there is what's called tzav kiyum tzava'a. which is the order of the will. And there is some people didn't forgot or didn't want or didn't write a will, and then it's a Tzav Yerusha. Tzav Yerusha is the inheritance law comes into effect, and then it's according to the inheritance law, according to the parentelot, it's the circles of relationship or relativity. So let's see what is the durable power of attorney allows you to do. It allows you to make decisions and to separate those decisions into three groups. As we said, one is personal. Within the personal, there's the medical, and then there's the financial affairs. And here you can choose just one person that is trustworthy, because this document can only be done with the person that you really, really trust, that will look after you. And some of my clients chose 2 or 3 children together to be there. If clients come and they said, first, we would like these 2 kids to be, these 2 children to be the people that will take care of me. And then they thought, well, it might actually hurt the other child that we didn't include him in taking care of us. So just for the sake of not hurting the child, add them to the document. So of course, the person that you choose has to agree to be the caretaker. You have to have their consent in writing, and they have to sign the document just as you are, but not together. It's very important here that to mention privacy. So when you meet a lawyer and you tell them how you'd like to run your affairs, it's important that the child that you nominate or the children will not be around, because we want to prevent, like I said, conflict of interest or influence on the person that nominates. So when it comes to your personal affairs, let's say if you're a male, you probably choose personally a son. If you have a son and a daughter, you choose the son, and if you're a woman, you choose the daughter, because it has to do with very personal things, like helping you to wash and get dressed, and very personal. And if you don't have a child or a daughter, a son or a daughter, you can say, okay, I'd like to have a specific caretaker, and you can say, look, I prefer them from this nationality. I prefer it to be a man or a woman at this age, from this nationality, and I'd like you to go through this process of screening them before you choose who will take care of me. And you can actually dictate the profile of the person that might live with you in the apartment, in the next room, and will take care of your breakfast, lunch, and dinner, and would change you, and that's the personal. When it comes to health, there's a variety of choices that you can make, that you can tell the children, and you can write it in the document, from DNR, from the do not resuscitate in certain cases, or regarding operation. Who of my children will be in the decision making if I have to go through a procedure? I know that I need a serious operation. I know if you have a child with a doctor, obviously you will nominate the child with the doctor to your health affairs. So again, you can choose one person to take care of everything, or you can say, my child with an accountant, they do better with my financial affairs. I'd like to nominate them for taking care of my bank accounts, if you have properties, overseas, or did you say I'd like them all to do it mutually to prevent bad blood between them, so there's no suspicion going on if one child handles it in an unfair way. So again, you can have the person who's the informed, or all the children together as nominees, appointees. I'm going to give time at the end for questions. take your questions. And so we said wills are for the day after, the power of attorney is during your life, and how do you get to a situation where it comes into effect? We said psychiatrist or a psychogeriatric doctor can write a report, but sometimes there is it's not necessarily comes with age. Not everybody get Alzheimer or get dementia. It can happen through a stroke. It can happen through a car accident that people lose their cognitive ability, and it needs to come into effect immediately. So it can happen to anyone, and that's why we recommend for anybody over the age of 40, 50 to have such a document. So you never know. Let's talk about the lawyer's duty, because before you write this document and sign it, you need to choose the lawyer. Let's see what's their duty. First of all, the lawyer, if you read the first page, I'm credited and approved by the Ministry of Justice. We have to go, the lawyers, not every lawyer can sign this. We have to go through a seminar of understanding exactly what are our duties and how to make the recommendations and give you all the choices that are there on the table before you sign such a document. The consultation is to be very precise, and then you choose the lawyer that you can trust. But what's their duty? The duty is the responsibility to explain the legal alternatives to you, as we mentioned, guardianship versus durable power of attorney, to make a tailor-made suit for you according to your needs, your desires, your abilities, and in according with your instructions. How would you like to live your life? And instructions can vary. I mean, let's say I love the sea, and we live here in Ranana, 15, 20 minutes away from the sea. I would like to write that once a week, I will be driven by a child or by my caretaker or by a taxi to sit in front of the sea, eat an ice cream, and watch the waves. And I want to write it down. I want 20 minutes, at least half an hour, to sit in the shade and watch the seagulls. That's something that if you write it there, more likely it will happen. If not, more likely it wouldn't. So that's an example. If you're a lady that usually you do your nails once in 2 weeks and you say, well, I'd like someone to take me or someone to come home and do my nails, to do my hair once in 2 weeks. And these are the people that are in charge of making it happen, the people that you appointed. And they have to bring or take you or bring over to your home somebody to do the manicure pedicure, because that's what you asked. This is your personal choices. And so you really, when you're cognitively strong and powerful and viable, you can project into your future. You can project that you are sitting down and you can't talk too well and you can't express yourself in appropriate manner, and say, okay, well, you know that certain things would happen as if you said them, but you said them when you were cognitively fine and it's in the document. So back to the lawyer, he must help you explore your future choices, as we said, privately, not with the appointee. And the person that you authorize to act on your behalf, we refer to them as the agent or the attorney in fact. They're not attorney, but they are in charge as attorney. You give them power of attorney. That term, power of attorney, is taken from, I'm sure many of you have given power of attorney to lawyers when you bought a property, sold the property, when you had a contract. So it's a legal term that usually refers to the lawyer, but here you appoint someone without legal experience or legal knowledge to be like a lawyer. That's the first, that's why this attorney in fact. Once, let's talk about the financial affairs and your financial affairs. It varies. the lawmaker said, yes, the person can act in your bank accounts, they can handle your financial affairs with a limitation. What is the limitation? Limitation has to do to two things mainly. One is real estate. A child or the nominated person cannot sell your property. You obviously can't say yes, no, you can't have an opinion there. So that's where the lawmaker said, okay, there we make decisions. There is no property sale without the court agreement. So let's say they really need the money in order to place you in a place that costs a fortune and you are forced to sell a property. That's fine, it's okay, but submit a request to the court. The court will review it, will see the needs, will see if it's really necessary, and will authorize it. So that, and not even with just selling a property. You know what's called הערת אזהרה? הערת אזהרה is that you put a note in the taboo about a certain property that in the future it will belong to this. So this property cannot be sold because we have interest in it, or that we put a down payment, or that we entitled to it at some point. These are comments that you can write in the taboo, in the registry of the property. You can't do that as a nominated person. Again, to put anything regarding properties, you need to go through the court. Another issue is cash. Cash money, the limit was 100,000 shekels. The law says that acts or withdrawals of more than 100,000 shekels are not allowed without the bank, without the court's approval. But that created a lot of problems for people who have great fortune. And they wanted the children to be able to move. Few millions here, a few millions there, and the court realized that 100,000 shekels can be a joke for them, and it really doesn't serve properly. And they corrected the law to 500,000 shekels. So now the nominee can make moves, withdrawals in your bank account of up to 500,000 shekels. Yeah. The choices that you are making, let's call them clever advanced directives. And why are they clever? They're clever because now you're so together. You came here to Yad Levani to listen to a lecture, to 2 lectures. You're cognitively strong and viable, and you can make decisions and directives. And it's as if the person is now sitting, let's say 20 years from now, sitting unable to speak, but the directions that he gives today are about to be implemented. And will specify your wish, your future actions, and what future actions will be made on your behalf. In conclusion, your instructions will guide the appointee how he or she should act in any matter regarding your life. We mentioned the informed. The informed, Ameyuda in Hebrew, it's really important to have someone like that. In terms of trust. Of course, some families have children that are more responsible versus other kids, other children that are not that responsible, that handle financial affairs not as careful. Some people gamble. You don't want to give a gambling child a power of attorney over your finances. It's not a good idea. But you can have them as informed, so they can help the caretaker to make important decisions. And it's not just one person, it's several, it's a team that looks after you. Again, the informed will, the nominated person will receive notification and be involved in supervision together with additional parties, the people you nominate. pricing. The Bar Association, together with the Ministry of Justice, stipulated 5,000 shekels per person to do this document. It's a document, it's a booklet that you sit with the lawyer and the lawyer actually listens to you, explain, you talk and you discuss together and you fill up this booklet. It's 5,000 shekels because the way they justify it, because it's not a one-off. It's a consultation and then meeting with you, then meeting with the nominated person, then the signatures. Once it's signed, we need to submit it to the ministry. The ministry sends it back to us with requests or corrections, and then we submitted the final. And we put it to sleep there until such time that the person becomes actually the need to activate it. We have a special. If you register today or this week, we give 20% on that. So instead of 5, it's 4,000. And for couples who do together, instead of 10, we give 30% off, which is only 7,000 shekels. I have a list here, so you're welcome to come and put your name. We can schedule a consultation if you decide to do so. Any questions? Yes, please.
I have a friend who's did one of these contracts. I had to develop Alzheimer's. He went to the bank and she told him what had happened, that she has a contract. The bank asked for the contract, saw it. Now every time she wants to draw up money, the bank said no, they've got to approve it. She said she didn't know about that before, and it makes her life so much more complicated. Is she right in that, or what?
It's true. The banks, part of what I deal with is the difficulties with that the banks actually put on people that becomes cognitively not okay, and the nominated person wants to come and withdraw money, and that's when we lawyers have to either write to the bank, submit the approval of the Ministry of Justice, and I'm talking quite often to bank managers, and I say, look, we have all the documents in place. Here are the approval, and but they're playing difficulties. It's true. Banks do.
But doesn't it? It's caused that problem that you try to solve. If she hadn't had this power of attorney, she would have just gone and withdrawn money on his behalf for his usage. And now, because of that contract, she has to now get the bank's approval for everything. Is that
not everything?
She does.
So, okay, it's not everything. It's usually for the first time. The first time, they want to make sure that they have all the right documentation. So you won't come in 5 years' time or 10 years' time, someone will come and say, look what you've done. We lost all my parents' money because you did the wrong thing. So the banks want to ensure, basically, to cover their ass, if you excuse my language. And therefore, for the first time, they want all the documentation. And that's when we, the lawyers, come into play, and we'll talk to the bank, or we submit, or we fax, or email them, whatever needed. And so they can file it, and from there on,
they should go back to a lawyer.
Yes, definitely. Okay. Definitely. Yes, please.
Yes, I'd like to know if you already have a durable in place and you want to make a change, do you have to submit it all over again? And is the cost again 5,000 shekels, or how?
Very good question.
Excuse me.
Thank you. Yeah, I'll answer it in a second. Yes, please.
Question, please.
Yes. My friend here is asking if you have already a power of attorney, but you want to make changes in it, you have to go back to the lawyer, do you have to resubmit, or just make corrections? Well, in a similar way to wills, you know, with the will, you can't correct the will. You have to write a new will. The last will always prevails. And similarly here, the power of attorney can be changed on certain conditions. Let's look at the conditions first of all. How can they change? Power of attorney, durable power of attorney, stop to exist if one of the two, the nominating person or the nominee, has passed away. it immediately revokes. Another way, if bankruptcy, if you nominated a child, but the child went bankrupt, he can't be your power of attorney. You can't use your durable power of attorney. Another thing is that sometimes people live into a very old age nowadays. Sometimes your child, you could be in your 90s, your child is in your 70s, and oops, they already slipping into Alzheimer's. So if they can't take care of you, it loses its power as well. And you're asking about making changes. You can first of all cancel it at any time if you haven't activated it. But let's say you activated it. There's a question asking you now when you prepare it, what happens if you would like to cancel it after you've activated, but you're not cognitively okay anymore? Will you still want it revoked, cancelled? And you have to decide on it now when you are okay. What will they do in such case? And the lawmaker gives you an option. You say, okay, even if I say no, do this with me. Either cancel it, don't cancel it, or keep me at home, even though there's recommendations that I will be sent to a elderly home, into a CUD department, but I will stay home. So there is a conflict between your wish and what the children decide. And you can, in the document, address this issue. What if we have a conflict? What prevails? And the lawmaker says the best thing is to talk to a psychogeriatric, to a psychogeriatric doctor, speak to them. They will be not just a decision maker, but they will explain to your children and according to your condition what is best. Yeah.
Maybe I didn't make myself clear. I'm just talking about changing a name. In other words, if we have two names on the contract, we want to change one of the names, for example. Does it have to go all the way through the court again, or is it just something?
It doesn't have to go through the court. It is the lawyer that made it can send to the Ministry of Justice a declaration. You need to sign what's called the tzab, taksir, a declaration that you sign and you change between children, between nominated people. Look, the lawyer will then only charge for his time, I imagine, not do the whole caboodle again and charge 5,000 shekels for it. If he puts an hour into that document, you should charge his hourly rate. Just like the cleaner, we clean the document. What's the difference? Any more questions, please? Yes, sir.
Once the jury is initiated, goes into effect, how are the expenses of various documents involved?
Well, it's an open question. I'll repeat. Once the durable power of attorney went into effect, what are the expenses involved to all the people around? And that's an open question. If you go to Protea Bahar, which is a nice retirement village in Shoresh, in the hills of Jerusalem, there's a very different price than if you go here to Amal or one of a local chain of so the expenses varies really, and especially if the person is staying at home and you need a caretaker, you need a living caretaker, and again that it has to do with your choices. If your choices are, I want to be one time a week, once a week, I'd like them to take me to a restaurant. I want to go out, sit in a restaurant after they did my hair, they dressed me beautifully. Even I'm in a wheelchair, they should wheel me and sit me in a restaurant, and I want to have my whatever you like. That adds to the cost. So it's really according to your choices. But the lawyer is not continuing to be paid. It's a one-off. That document, as I said, the 5,000 shekels or 4,000, it's a one-off. And then the other caretakers it varies.
Ministry of Justice doesn't charge.
The Ministry of Justice doesn't charge anything more than just submitting the document. So all their clerks, go through the document and make sure that everything is okay. So no more expenses. It should be a money saver, not a ongoing expense. It's an expense that should be giving you peace of mind, should be giving you comfort, and living a lifestyle that you'll be proud to live, and everybody would be proud of you. You'll be proud of you in a dignified way. You'll keep your dignity because you nominated the right people and you made the right choices. So yeah. So how many of you have? Yes, please. Yeah. Sorry, I didn't hear the first one. Not true. No. It's valid for life. Yeah, it's durable. It's forever. Absolutely. The funds is your funds, and you choose how it will be paid in the future by your daughter, your son. You can choose who it's paid, but you can't choose that somebody else will pay on your behalf. That's, that would be nice. Everybody would have chose this. The person next to you raised the hand, right? No, okay. Yeah, so yes, please, sir. In Israel, it's very different. I assume you come from a country where attorney and a lawyer is different. I know in Australia, when you buy a property, you go to a solicitor, to a conveyancer. Is the lawyer that's conveyancer. If you go into court, you need a barrister. In Israel, there is only one form. It's called lawyer, orech din. I know that many people raise eyebrows. They say, oh, quite astonished by the fact that someone can go to university, finish 3 years, get the bar association approval, and the next day they can go into court and represent you with $100 million lawsuit. They can do that. In other countries, they can't. In Australia, as I said, you need a barrister, and a barrister is a different format of a lawyer. In Israel, once you get the certificate of a lawyer, you can do all of them. Besides certain things, I mean, if you want to be if someone goes into receivership, if a corporate law is different. In corporate law, you need certain years, 5 years of experience or 10 years of experience to be a notary public. You need 10 years of experience. But for as far as power of attorney, durable power of attorney, I mentioned to you that I only went to law school when I was 53. And when I finished law school and went through the course of how to do durable power of attorney, next to me sat lawyers that have been 30, 40 years lawyers before me, but they don't have any advantage. The fact that we studied this mechanism and how to do it and specialize in it, well, we know how to craft it together, how to submit, how to tell you about your choices, inform you, and help you get to the best, as I said, tailor-made document that would foresee your future. So how many of you have done durable power of attorney so far? One. Ooh, quite a lot of you. Amazing. And when it comes to wills, because it's really recommended to have both, to have the power of attorney and a will. And how many of you have wills written? Most of you. Fantastic, fantastic. So you are well taken care of, crowd. Thank you very much for being here today. There's more questions, please. Very good question. Thank you. What's your name, please? Esther. Thank you. This is a wonderful question. Many people ask, written a will. Why do I need a power of attorney, durable power of attorney? I said in the will what goes to who and what they're getting. Can't they figure it out? It's in the will. The thing is that the will should only be opened up after the funeral. Even if they know the, yeah, but the will, you know that even if the will is not kept secret, even if the will is not kept secret, in order for a will to have an effect, as I said, it needs to go to the Ministry of Justice, and you need an order of the will. It's called Tzav Kiyum Tzava'ah. It's an order of the will, so the court has to give you a stamp, and now this will is authorized. Means with that will, each of the children can go to the bank and take over and get their shares according to the will, and the entire estate is being split according to the will after the court has stamped it. The will has no power before the person is deceased. So as I said, the durable power of attorney is for the time until 120. When we pass 120, then the will come into effect. Yes, please.
How, for instance, the authorities like the bank or something like that know when this durable power of attorney has come into effect? What is the actual process?
Okay, they don't. The banks are not linked to the Ministry of Justice, and they're not getting report about every client and when they become legally incompetent. So the person that you nominated will activate that document during the power of attorney once you lost your cognitive ability, and then it's their responsibility to go to the bank and show the bank and say, here, look, my mom or my dad are now under my auspices. I'm the guardian without being apotropos. I'm like a apotropos. And they have to show it to the bank. The bank will photocopy the documents, and then they know that it came into effect.
They activate it. It's the person who is the power of attorney. How do they activate it?
Okay, the best way is to inform the lawyer that submitted. Now, the lawyer might pass away already or change profession or move to Belgium or to Australia, and you can't find them. So then it takes a letter to the Ministry of Justice, to the department, the register of register of wills, register of power of attorneys. And yes, please.
At a certain point in your your address, you mentioned that the law had been changed somewhat. We had made jointly powers of attorney during powers of attorney. Do we need, and this was about soon after the law came into effect, do we need to have them reviewed in order to see if we take advantage of the changes in the law?
Absolutely, that's a very good question. So let's say you signed power of attorney or you signed guardianship.
No.
Guardianship is apotropsut. So some
An enduring power of attorney.
there's an enduring power of attorney, but you want it changed or you did.
In the light of changes in the law, which I think you mentioned,
Absolutely. The question is, if you've done it overseas, the enduring power of attorney, you've done it here in Granada. So it should be submitted. Is it being submitted?
Yes.
If it's been submitted, you have the right to cancel it and change it and do another one instead. I don't see why it will not be respected by the law if you've done it before the law came. Because that actually very wise.
Certainly, I heard that the changes set out by the Ministry of Justice in the format of the powers that can be given, not given. And I want to know whether our powers of attorney, which were given several years ago, in fact, very soon after the law was enacted, whether we need to see whether there are any provisions of that change which we need to be aware of necessary.
It is recommended because there's changes all the time. One of the changes, even if you have power of attorney, as I mentioned, that they changed the ability to withdraw from 100,000 shekels to 500,000 shekels. That's a change that exists already. If you want to have it overlooked, I think it should be taken out by the lawyer who did it, or other lawyer that can withdraw it or can retrieve it from the ministry. You go over it and you make sure that it actually suits what you want today and not what you've written, I don't know, 5 or 7 years ago. It is recommended, absolutely. Get it overlooked and make sure that all the decisions you make back then are still applicable for you. Sure, then resubmit. Yes, please.
Is there any specific or recommendation about the language?
So the Ministry of Justice will not send us to court with Hebrew or English. These two languages you can do and they'll accept it. If it's other language, they want you to go to a notary public, have it authorized by a proper translator, and have all the documentations regarding the translation. And yeah, Hebrew and English, no problem. Yes. So, yes, sir.
Some notaries ask for the check with public machine, we or a bill very notary. Is it true?
Okay. Thing, a lawyer is an officer of the court, but he doesn't have the power like a court. Notary public, yes. If you go to a notary public and you authorize the document by notary public, it can replace the court. When it comes to durable power of attorney. Durable power of attorney can be made only by lawyers that got the accreditation by the Ministry of Justice, and they must submit it to the register and get it approved. I've submitted documents and sometimes they reject it, saying, mostly it's technical lawyers sitting there and they say, oh, you forgot to write a date here, or the nominee signed, but they didn't write the date that they signed, but some taudat zehut, some ID is missing somewhere. So they look at it technically, and if everything okay, they give an approval that it has been submitted. You must do that. There's no shortcuts around. There's not enough to have a stamp of a lawyer or a notary public, not when it comes to durable power of attorney. Now, you also asked me about wills. When it comes to wills, there are several ways to authorize a will. There are what's called tzava'a be'edin. You can have a will with 2 witnesses without a lawyer. You can call the neighbor. If they're over 18, say, can you come here, please? Can you, with your taudat zehut, this is my will, I've written it. I'm going to sign it in front of you. The 2 neighbors, it cannot be the person that signs. One of these 2 cannot be anybody who's a beneficiary of your will. It's not a child, it's not someone, it's not your helper, that now convince you to give your diamond ring to her, and now it's written in the will. No, it needs to be someone without any relations to the as a beneficiary, and then they can sign as witness, and 2 witnesses are enough, and that will is viable. That will is authorized. Now, what you can do with this will after you've signed it in front of 2 witnesses, you can keep it in your drawer, give a copy to your children, but you can also submit it to the Ministry of Justice, לרשם הירושות, the wills register, and they put it in the system, and it's there. So you don't have to worry, wow, what if I get run over by a bus in Haifa, and then nobody knows where's my will? I didn't tell anyone, and I didn't give a copy to anyone, and now it's not going to be respected because no one knows about it. Well, you want that someone will for sure know about it. The best way is to submit it to the ministry, and the lawyer and that's one way of writing a will is called tzava'a be'edim, is with 2 witnesses. Another way is to go to a notary public and have him stamp it without submitting it to the court, without submitting it to the register. And another is to do it with a lawyer. But as a lawyer, when I write wills, I'm one of the witnesses. Of course, I'm not a beneficiary. I'm one of the witnesses. Usually we call someone else in the office and say, come and be another witness. That person needs to be over 18. That's the only, over 18 and not a beneficiary. And that's the only requirement. Another way to write a will is called the tzava'a b'chtav yad. Chtav yad is your own handwriting. If you write a tzava'a in your own handwriting and you submit it, it still can be authorized by the Register of Wills.
Without witnesses or with witnesses.
It needs witnesses, yeah. But you've written it in your hand, but it means you don't necessarily need a lawyer. You can write one with your own handwriting. 2 witnesses has to actually declare what's the signature of the witnesses. Is a declaration that they realize that nobody put pressure on you, unfair influence, and that you did it when you cognitively your mind is in place. Yeah. All right, everyone. Thank you very much. Yes, please, Esther. Notary public is someone who's been a lawyer for over 10 years and goes through a specific course that the Ministry of Justice takes them, and now they can have an extra authority. They have a stamp of a notary public. Thank you very much. I'm here. Thank you. I'm here with the links. If you'd like to get a consultation, come and put your name down and we'll contact you. Thank you. Thank you.